Hey guys, I'm the Spuddler. Welcome to my channel. This one is going to be dry, dry, dry. And I've put it together just because I think it might be decent reference for people. I was looking into freedom of speech and I kind of segued into Tennessee and the laws that they've got for protection and the implications legally of what's about to happen to a certain person that we know. So I've kind of put it together with a voiceover so it's easier to understand. If you're interested in the legal side of it and what to expect later and what's going on at the moment, from the legal perspective, I've basically just put that together for you. It's not comprehensive. It's literally very dry because it's directly quoted from the legal statutes, the legal chapters, etc., etc. Because I'm not a lawyer, I have absolutely no idea or could advise anyone, although I have a pretty good idea about some things. But I think it's there really for everybody to read. And so we're all on the same page for later this week and next week. And really understanding the BS from the facts from the legal perspective. So hopefully you're going to enjoy it. You'll probably need to take it in sections. And some of it you won't be interested in. And some of you won't be interested at all. But some of you might find it really interesting, especially because I'm fascinated with legals. And I really do want to understand what's being said and understand from the legal perspective quite how true it all is. So I'll get on with the intro. We can get into reading these documents together. And really, as I said, it's not for everybody. I don't expect many views, but I'm hoping that some people just might find it a good reference to use themselves when they're discussing or thinking about Bullhorn Betty's case and the protective order against her from the families of a missing child.
The Universal Declaration of Human Rights, UDHR, is a milestone document in the history of human rights. Drafted by representatives with different legal and cultural backgrounds from all regions of the world, the declaration was proclaimed by the United Nations General Assembly in Paris on December 10, 1948, as a common standard of achievements for all peoples and all nations. It sets out, for the first time, fundamental human rights to be universally protected, and it has been translated into over 500 languages. Article 19. Everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media, and regardless of frontiers.
What is freedom of speech? Freedom of speech is the right to say whatever you like, about whatever you like, whenever you like. Right? Wrong. Freedom of speech is the right to seek, receive, and impart information and ideas of all kinds, by any means. Freedom of speech and the right to freedom of expression applies to ideas of all kinds, including those that may be deeply offensive. But it comes with responsibilities, and we believe it can be legitimately restricted. Does freedom of speech have limits? You might not expect us to say this, but in certain circumstances, free speech and freedom of expression can be restricted. Governments have an obligation to prohibit hate speech and incitement. These are dangerous. Restrictions can also be justified if they protect specific public interest or the rights and reputations of others. Any restrictions on freedom of speech and freedom of expression must be set out in laws that must in turn be clear and concise so everyone can understand them. People imposing the restrictions, whether they are governments, employers, or anyone else, must be able to demonstrate the need for them, and they must be proportionate. All of this has to be backed up by safeguards to stop the abuse of these restrictions and incorporate a proper appeals process.
Congress shall make no law, respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people, peaceably to assemble, and to petition the government for a redress of grievances.
The First Amendment of the United States Constitution protects the right to freedom of religion and freedom of expression from government interference. It prohibits any laws that establish a national religion, impede the free exercise of religion, abridge the freedom of speech, infringe upon the freedom of the press, interfere with the right to peaceably assemble, or prohibit citizens from petitioning for a governmental redress of grievances. It was adopted into the Bill of Rights in 1791. The Supreme Court interprets the extent of the protection afforded to these rights. The First Amendment has been interpreted by the court as applying to the entire federal government, even though it is only expressly applicable to Congress. Furthermore, the court has interpreted the Due Process Clause of the 14th Amendment as protecting the rights in the First Amendment from interference by state governments. Freedom of speech, freedom of the press. The most basic component of freedom of expression is the right to freedom of speech. Freedom of speech may be exercised in a direct, words, or a symbolic, actions, way. Freedom of speech is recognized as a human right under Article 19 of the Universal Declaration of Human Rights. The right to freedom of speech allows individuals to express themselves without government interference or regulation. The Supreme Court requires the government to provide substantial justification for interference with the right of free speech when it attempts to regulate the content of the speech. Generally, a person cannot be held liable, either criminally or civilly, for anything written or spoken about a person or topic, so long as it is truthful or based on an honest opinion and such statements. A less stringent test is applied for content-neutral legislation. The Supreme Court has also recognized that the government may prohibit some speech that may cause a breach of the peace or cause violence. The right to free speech includes other mediums of expression that communicate a message. The level of protection speech receives also depends on the forum in which it takes place. Despite the popular misunderstanding, the right to freedom of the press, guaranteed by the First Amendment, is not very different from the right to freedom of speech. It allows an individual to express themselves through publication and dissemination. It is part of the constitutional protection of freedom of expression. It does not afford members of the media any special rights or privileges not afforded to citizens in general.
A restraining order is a court order enjoining a person from taking a particular action in relation to another person. Also referred to as a temporary restraining order, TRO. Restraining orders are often issued in cases of domestic violence. A restraining order has a similar function to a preliminary injunction, the major difference often being that a preliminary injunction requires notice to the enjoined party, whereas a restraining order does not. For civil cases in federal court, Federal Rule of Civil Procedure Rule 65 requires a party seeking a restraining order to show that they would suffer immediate and irreparable injury, loss, or damage without the order and reasons why notice should not be required. Many states allow individuals to request restraining orders if they are victims of certain crimes relating to domestic violence.
A. Upon the filing of a petition under this part, the courts may immediately, for good cause shown, issue an ex parte order of protection. An immediate and present danger of abuse to the petitioner shall constitute good cause, for purposes of this section. Within 15 days, of service of such order on the respondent under this part, a hearing must be held, at which time the court shall either dissolve any ex parte order that has been issued, or shall, if the petitioner has proved the allegation of domestic abuse, stalking of a minor, offense by a preponderance of the evidence, extend the order of protection for a definite period of time, not to exceed 1 year, unless a further hearing on the continuation of such order is requested by the respondent or the petitioner, in which case, on proper showing of cause, such order may be continued for a further definite period of 1 year, after which time a further hearing must be held for any subsequent 1-year period. Any ex parte order of protection must be in effect until the time of the hearing, and, if the hearing is held within 15 days of service of such order, then the ex parte order must continue in effect until the entry of any subsequent order of protection, issued pursuant to 36-3-609. If no ex parte order of protection has been issued as of the time of the hearing, and the petitioner has proven the allegation of domestic abuse, stalking, by a preponderance of the evidence, then the court may, at that time, issue an order of protection for a definite period of time, not to exceed 1 year. C. The court shall cause a copy of the petition, and notice of the date set for the hearing on such petition, as well as a copy of any ex parte order of protection, to be served upon the respondent at least 5 days prior to such hearing. An ex parte order issued pursuant to this part shall be personally served upon the respondent. However, if the respondent is not a resident of Tennessee, the ex parte order shall be served pursuant to 20-2-215 and 20-2-216. Such notice shall advise the respondent that the respondent may be represented by counsel. In every case, unless the court finds that the action would create a threat of serious harm to the minor, when a petitioner is under 18 years of age, a copy of the petition, notice of hearing and any ex parte order of protection, shall also be served on the parents of the minor child, or in the event that the parents are not living together and jointly caring for the child, upon the primary residential parent, pursuant to the requirements of this section. D. Within the time the order of protection is in effect, any court of competent jurisdiction may modify the order of protection, either upon the court's own motion or upon motion of the petitioner. If a respondent is properly served and afforded the opportunity for a hearing pursuant to Section 36-3-612, and is found to be in violation of the order, the court may extend the order of protection up to 5 years. If a respondent is properly served, and afforded the opportunity for a hearing pursuant to Section 36-3-612, and is found to be in a second, or subsequent violation of the order, the court may extend the order of protection up to 10 years. No new petition is required to be filed, in order for a court to modify an order or extend an order pursuant to this subsection D.
So I'm just going to read you now the information that's relevant from the Temporary Order of Protection, Ex Parte Order of Protection, that was in the General Sessions Court of Sumner County in Tennessee. I'm not going to give you the specific details of the names, you could read those yourselves, but I will give you the poignant details. So this says, the court, having reviewed the petition of temporary order of protection and finding pursuant with TCA 36-3/605A that petitioner is under an immediate and present danger of abuse from the respondent and good cause appearing, the court has issued the following. The orders to the respondent are: do not abuse, threaten to abuse, hurt or try to hurt or frighten a petitioner and or petitioner's minor children under 18. Do not put petitioner and or petitioner's minor children under 18 in fear of being hurt or in fear of not being able to leave or get away. Do not stalk or threaten to stalk petitioner and or petitioner's minor children under 18. Do not come about the petitioner and or the petitioner's minor children protected by this order, including coming by or to the shared residence for any purpose. Do not contact the petitioner and or petitioner's minor children protected by this order, either directly or indirectly by phone, email, messages, mail, or any other type of communication or contact. You must not harm or threaten to harm any animals owned or kept by the petitioner, petitioner's children. Other orders: do not interfere with property owned or kept by petitioner or with utilities of the home. You must obey these orders until the date of the hearing or until changes are made by the court. If you do not agree with these orders, go to the court hearing and tell the court why. If you do not go, the court can make orders against you. You have the right to bring your own lawyer. You may be fined or sent to jail. Only the court can change this order. Neither you nor the petitioner can agree to change this order. Even if the petitioner tries to contact you or agrees to have contact with you, you must obey this order. If you do not, you can be sent to jail for up to 10 days and fined up to $50 for each violation. Warnings to respondent. A copy of this order will be sent to the law enforcement agencies where petitioner resides, and any court in which the respondent and petitioner are parties to an action. Any law enforcement officer who reasonably believes you have disobeyed the order may arrest you. If you hurt or try to hurt anyone while this order, probation, or diversion is in effect, you may face separate charges of aggravated assault, a Class C felony.
A. It is an offense to knowingly violate 1. An order of protection issued pursuant to Title 36, Chapter 3, Part 6, or 2. A restraining order issued to a victim as defined in Section 36, 3.601. B. A person violating this section may be arrested with, or without a warrant, as provided in Section 36, 3.611, and the arrest shall be conducted in accordance with the requirements of Section 36, 3.619. C. A person who is arrested for a violation of this section shall be considered within the provisions of Section 40.11.150a and subject to the 12-hour holding period authorized by Section 40.11.150h. D. After a person has been arrested for a violation of this section, the arresting officer shall inform the victim that the person has been arrested, and that the person may be eligible to post bond for the offense, and be released until the date of trial for the offense. E. Neither an arrest, nor the issuance of a warrant, or capias for a violation of this section in any way affects the validity or enforceability of any order of protection, restraining order, or no contact order. F. In order to constitute a violation of subsection A, 1, the person must have received notice of the request for an order of protection or restraining order. 2. The person must have had an opportunity to appear and be heard in connection with the order of protection or restraining order, and 3. The court made specific findings of fact in the order of protection or restraining order that the person committed domestic abuse, SA, or stalking as defined in Section 36, 3.601, or was convicted of a felony offense under Chapter 13, Part 1, 2, 3, or 5 of this title. G. A violation of subsection A is a Class A misdemeanor. Notwithstanding Section 40.35.111e1, a violation of subsection A is punishable by a fine of not less than $100, nor more than $2,500, and any sentence of incarceration imposed shall be served consecutively to the sentence for any other offense that is based in whole, or in part, on the same factual allegations. However, the sentencing judge or magistrate may specifically order the sentences for the offenses arising out of the same facts to be served concurrently. H. 1. It is an offense and a violation of an order of protection for a person to knowingly possess a firearm while an order of protection that fully complies with 18 U.S.C. Section 922 G8 is entered against that person, and in effect, or any successive order of protection containing the language of Section 36, 3606 F, and that fully complies with 18 U.S.C. Section 922 G8 is entered against that person and in effect. 2. For purposes of this subsection H, the determination of whether a person possesses firearms shall be based upon the factors set out in Section 36, 3.625 F, if the firearms constitute the business inventory or are subject to the National Firearms Act. 3. A violation of this subsection, H, is a Class A misdemeanor, and each violation constitutes a separate offense. 4. If a violation of subsection, H, also constitutes a violation of Section 36, 3, 625, H, or Section 39, 17, 1307, F, the respondent may be charged and convicted under any or all such sections. 1. It is an offense to knowingly violate a no-contact order, issued prior to a defendant's release on bond, following the defendant's arrest for any criminal offense defined in this chapter, in which the alleged victim of the offense is a domestic abuse victim as defined in Section 36, 3, 601. 2. A violation of subdivision, A1, is a Class A misdemeanor. A sentence imposed must be served consecutively to the sentence for the offense for which the defendant was originally arrested, unless the sentencing judge or magistrate specifically orders the sentences for the offenses to be served concurrently. A. Upon violation of the order of protection or a court-approved consent agreement, the court may hold the defendant in civil or criminal contempt and punish the defendant in accordance with the law. B1. In addition to the authorized punishments for contempt of court, the judge may assess any person who violates an order of protection or a court-approved consent agreement a civil penalty of $50. The judge may further order that any support payment made pursuant to an order of protection or a court-approved consent agreement be made under an income assignment to the clerk of court. B2. The judge, upon finding a violation of an order of protection or a court-approved consent order, shall require a bond of the respondent until such time as the order of protection expires. Such bond shall not be less than $2,500 and shall be payable upon forfeit as provided. Bond shall be set at whatever the court determines is necessary to reasonably assure the safety of the petitioner as required. Any respondent for whom bond has been set may deposit with the clerk of the court, before which the proceeding is pending, a sum of money in cash equal to the amount of the bond. The clerk of the court may deposit funds received, in lieu of bonds, or any funds received from the forfeiture of bonds, in an interest-bearing account. Any interest received from such accounts shall be payable to the office of the clerk. Failure to comply with this subsection, B, may be punished by the court as a contempt of court as provided in Title 29, Chapter 9. B3. If a respondent posting bond under this subsection B does not comply with the conditions of the bond, the court having jurisdiction shall enter an order declaring the bond to be forfeited. Notice of the order of forfeiture shall be mailed forthwith by the clerk to the respondent at the respondent's last known address. If the respondent does not within 30 days from the date of the forfeiture satisfy the court that compliance with the conditions of the bond was met, the court shall enter judgment for the state against the defendant for the amount of the bond and costs of the court proceedings. The judgment and costs may be enforced and collected in the same manner as a judgment entered in a civil action.
On the 22nd of August 2024, 3 separate protective orders were granted against the defendant by General Sessions Judge John Blanton. The petitioners on the protective order are KP, TB and MB. According to the orders, the defendant cannot come about the petitioners for any purpose and must not contact them or their children, either directly or indirectly, by phone, email, message, text messenger, mail or any other type of communication or contact. On the 22nd of August 2024, shortly after the hearing, the petitioner learned the defendant went live on her YouTube channel, Bullhorn Betty, and proceeded to blast how people were talking on social media about court and what took place because the defendant failed to appear for court. The defendant threatened to sue the P's and the B's multiple times and hashtagged them and their minor son for her YouTube stream Can't Fix Stupid, Tennessee. On August the 22nd at approximately noon, your affiant received information from KP that the defendant was live streaming again on her YouTube channel, Bullhorn Betty, The affiant watched the live stream which showed the defendant driving while videotaping her feed. During this live stream, the defendant again threatened to sue the P's and the B's. The live stream, entitled "The Garbage of YouTube," had hashtag CP, KP and their minor son listed on it. Based on these facts and statements, your affiant believes the defendant has violated the conditions of the 3 separate protective orders twice this date. Therefore, your affiant is charging the defendant with 6 counts of violation of an order of protection, TCA 39/13/133. These offences did occur in Sumner County, Tennessee.